Our finding on whether there was a breach of Article 10, Sub-Article 2 of the Constitution in the issuance of an EIA license to the first respondent for the impugned road project is in the negative. Issue number Roman 2B, whether construction of the proposed Mau Mau Lot 4, Ihize Ndunyu Road, Ihize Ndunyu Njeru Road violates Article 11 of the Constitution. Article 11 of the Constitution recognizes culture as the foundation of the nation and as the cumulative civilization of the Kenyan people and nation. It obligates the state to, 1, promote all forms of national and cultural expression through literature, the arts, traditional celebrations, science, communication, information, mass media, publications, libraries, and other cultural heritage. And 2, it recognizes the role of science and indigenous technologies in the development of the nation. And lastly, it obligates the state to promote the intellectual property rights of the people of Kenya. The petitioners and the fourth interested party allege that the proposed road project violates the above constitutional framework. They contend that the Aberdare ecosystem is a natural environment that is a cultural landscape that is deeply intertwined with the cultural identity, spiritual practices, traditional ecological knowledge, and the historical memory of the surrounding communities and the country. They add that the Aberdare ecosystem forms part of Kenya's national heritage. They faulted the Asia study report for failing to make reference to cultural sites, traditional knowledge, or heritage considerations. They contended that in June 2023, the second interested party submitted the Aberdare Mountains to the tentative list of UNESCO World Heritage Sites. They have, however, not tendered any evidence to support the allegation of listing on the UNESCO World Heritage Sites. The respondents deny the allegation of violation of Article 11 of the Constitution and fault the petitioners for failing to tender evidence to substantiate the allegation. We have considered the allegation of violation of Article 11 of the Constitution in the context of the above constitutional framework and the evidence placed before us. In its totality, the evidence before us does not disclose the alleged violation of Article 11 of the Constitution. It was the duty of the petitioners to present evidence that demonstrates the alleged violation or threat of violation of Article 11. The Supreme Court of Kenya in Igwere and 5 others versus Kenya Medical Research Institute and 3 others emphasized that the burden placed on a petitioner by sections 108 and 109 of the Evidence Act to tender evidence to prove allegations made in a petition. I'll read it again. That the Supreme Court of Kenya in Igwere and 5 others versus Kenya Medical Research Institute and the 3 others emphasized the burden placed on a petitioner by sections 108 and 109 of the Evidence Act to tender evidence to prove allegations made in a petition. It is a tried principle of law that in the absence of evidence, the allegation of violation remains an unproven allegation. Consequently, because no evidence was tendered to prove the allegation of violation or threatened violation of Article 11, we make a finding that the said allegation was not proved. That is issue number Roman 2C, whether the intended construction of the proposed road violates Article 42 of the Constitution. The petitioners and the fifth interested party contended that the proposed construction will violate the right to a clean and healthy environment that is envisaged in Article 42 of the Constitution. They argue that construction of the road will cause harm to the Aberdare ecosystem, drain wetlands, worsen climate change, and reduce the tree cover, and therefore the right to a clean and healthy environment will be violated. They stated that the social harms to be occasioned by the road outweigh its economic benefits. They allege that clearing of tree cover along a stretch of 25 kilometers of closed canopy forest will increase pollution of the air and will lead to an unhealthy environment. They assert that the right to a clean and healthy environment, which encompasses the preservation of ecological health, biodiversity, aesthetic values, and the integrity of natural ecosystems, such as the Aberdare water towers and the Aberdare forest, will be affected by the road project. They argue that the Asia study report, which informed the issuance of the impugned EIA license, acknowledges that the proposed road passes through the Aberdare ecosystem, which is a rich biodiversity forest and has major water towers. They further argue that a huge chunk of trees and vegetation, including bamboo trees, will be cleared to pave way for the road in the protected areas. For the above reasons, they contend that the proposed road will result in a violation of Article 42 of the Constitution. They rely on the case of Badi and others versus Attorney General and 7 others, in which the court held that, and I quote, any action that will cause environmental, ecological, or water pollution should be regarded as amounting to violation of the right to life. Close the quote. In response, the first respondent contests the above allegations. They state that the impugned project is an intended upgrade. They stated that the impugned project is an intended upgrade of an existing motorable road from Maram to bitumen standard. They asserted that the road has existed and has been in use for many decades, dating to pre-independence period. They further stated that the intended road project has complied with all constitutional and statutory requirements, adding that the project is in the public interest. They contend that the road will benefit the people socioeconomically once it is upgraded in conformity with the conditions in the EIA license dated 5th of January 2024. The first respondent states that all the concerns raised by the petitioners and the fifth interested party have been exhaustively addressed through the measures provided in 1, the Asia study report, and 2, the conditions in the Asia license, and 3, the recommendations in the joint technical report dated August 2023. The first respondent emphasized that the road in question is an existing road, which is a Maram road and causes more harm to water, especially during the rain season, when soil sediments are washed and deposited in the wetlands and in the water towers. They add that in contrast, upgrading of the existing earth road to bitumen standard will prevent washing of soil into the existing wetlands and the water towers and will contribute to a clean and healthy environment. The first respondent asserts that although the petitioners and the fifth interested party have alleged the violation of Article 42, they have not proved any of the alleged violation. They further argue that the Asia study report has provided exhaustive mitigation measures which they intend to implement to mitigate the impact of the upgrading of the existing road to address the concerns raised by the petitioners and the fifth interested party. The first respondent relies on the case of Scaliel versus KeNHA Railways Corporation and 5 others, where the court held as follows, and I quote, that this court and the law required of the petitioner, having received a copy of the Asia report, either from the first interested party or through the reply by the first respondent, to elaborate why they formed the opinion that the mitigating measures stated were not sufficient to protect them and the environment. End the quote. We have considered the above rival arguments. Article 42 of the Constitution provides as follows, and I quote Article 42, that every person has the right to a clean and healthy environment, which includes the right to A, have the environment protected for the benefit of present and future generations through legislative and other measures, particularly those contemplated in Article 69, and B, to have obligations relating to the environment fulfilled under Article 70. Close the quote. Article 70 states that if a person alleges that a right to a clean and healthy environment recognized and protected under Article 42 is being or is likely to be denied, violated or infringed or threatened, the person may apply to court for redress, in addition to any other legal remedies that are available in respect to the same matter. It is in line with the above provision of Article 70, Sub-Article 1 of the Constitution that the petitioners filed the instant petition, alleging that their right to a clean and healthy environment is likely to be violated by the road project. Being the persons who have alleged, the petitioners had a duty to adduce sufficient evidence to prove their allegations. We have independently evaluated the relevant ECA study report and the conditions attached to the ECA license in the context of the allegation of violation of the right to a clean and healthy environment. The relevant ECA study report and the impugned EIA license were exhibited as annexures to Ms. Nancy Ogonje's affidavit. Besides the affidavits and the oral evidence that were tendered, the court visited the locals in Kwa. The visit confirmed that there exists a motorable Maram road that is in use. Indeed, the court and the entourage used the existing Maram road. The court also confirmed that there exists an open canopy above the road, which has 25 kilometers traversing the Aberdare Forest Reserve and the National Park. The court confirmed that the project will, in the circumstances, not entail the establishment of a new road in a forest where none exists. The project will entail an upgrade of an existing motorable Maram road to bitumen standard. The project will, however, entail widening of the existing motorable Maram road. There is common ground that there will be some destruction of forest along the 25 kilometers of the forest stretch of the existing road due to the upgrading. Have the first and fourth respondents put in place adequate mitigation measures? First, the first respondent tendered evidence showing that the intended road has been redesigned to reduce its width so that the forest cover that is affected along the existing road is minimized. Secondly, at pages Roman 11 to Roman 17 of the ECA study report, the first respondent has identified the likely environmental impacts of the project and has come up with clear mitigation measures. The ECA study report acknowledges that the project is going to impact on the vegetation. With regard to the impact of reduced vegetation cover and above ground biomass, the identified mitigation measures in the ECA study report are as follows, and I'm quoting the ECA study report. Cleared trees should be kept within the forest and should be used in order to prolong the period of carbon emission. Size should be identified for offsetting the loss of forest cover and biomass. This will require an adoption of compensation plan. Close the quote. We have looked at the section of the ECA study report covering economic and social management and monitoring. It identifies various impacts at various phases of the project and provides mitigation measures for each identified impact. The relevant schedule of the identified impacts and the proposed mitigation measures are at pages Roman 12 to Roman 17 of the ECA study report. We have evaluated each of the identified impact and the respective proposed mitigation measures. We have also looked at the conditions set out in the impugned EIA license. The EIA license contains many conditions categorized as follows. 1, general conditions. 2, construction conditions. 3, operational conditions. 4, notification conditions. And 5, decommissioning conditions. Condition 2.7 relates to forest cover and biomass. It provides as follows, and I'm quoting condition 2.7, that the proponent shall develop and implement a comprehensive offset and compensation plan for the 75 hectares of bamboo, 14 hectares of montane forest, and 14 hectares of moorlands with an estimated total biomass of 5,662 mg HA-1, moorland 177 mg HA-1, bamboo 4,300, and forest HA-1185 mg H1-1 that shall be lost in the construction of the road section traversing Aberdare's Forest Reserve and National Park. The offset and compensation plan shall be authorized and supervised by the lead agencies responsible for the conservation and management of the national water towers, forests, and wildlife. The implementation monitoring shall be reported to the authority on an annual basis through environmental audit reports in line with Section 68 and 69 of the EMCA. Close the quote. Our evaluation of the mitigation measures as contained in the ESIA study report and in the conditions attached to the EIA license is that the measures are exhaustive. If all the mitigation measures are implemented as outlined in the ESIA study report and in the EIA license, the affected environment will be safeguarded and will be clean and healthy. We have considered the arguments presented by the rival parties, and we concur with the holding of the court in the Scaliel case that the party alleging violation has a duty to elaborate why they formed an opinion or believed that the mitigation measures stated in the ESIA report were not sufficient to protect them and the environment. The petitioners have not tendered evidence to challenge the mitigation measures proposed in the ESIA study report. We have also taken into account what various courts have held with regard to construction of roads vis-a-vis the right to a clean and healthy environment invested in Article 42 of the Constitution. In a persuasive pronouncement in Save, Lam, and 5 others versus Nema and another, the National Environment Tribunal stated as follows, and we are quoting the tribunal as a persuasive pronouncement, that Article 42 is not a veto. The right to a clean and healthy environment does not mean that development must stop. It means that development must be sustainable. Close the quote. In the same case, the tribunal held that where the EIA license identifies impacts and provides adequate mitigation measures, the projects should be allowed to proceed, adding that the socio-economic benefits should be weighed against the environmental costs. Having evaluated the evidence that was presented in the petition, we come to the conclusion that adequate measures have been put in place to ensure that the right to a clean and healthy environment is not violated or threatened by the upgrading of the existing Ihithe-Nduyunjeru Road. Consequently, it is our finding that if the mitigation measures are implemented, it is our finding that if the proposed mitigation measures are implemented and the license conditions are enforced, the construction of the said road will not violate Article 42 of the Constitution.
Okay, thank you. I'll deal with issue number 2, sub-article D, whether the said construction will violate Article 69 of the Constitution. The petitioner and the fifth interested party allege that the respondents have not adhered to the principle of sustainable development as provided by Article 69 of the Constitution, adding that the respondents have failed to honor the obligations in respect of the environment. They contend that the construction of the road will lead to loss of biodiversity, which is a violation of Article 69, sub-article 1, E and G, which obligates the state to protect genetic resources and biological diversity and eliminate processes and activities that are likely to endanger the environment. They add that allowing the road to pass through the Aberdare Forest Reserve will result in a tree cover loss, which is against Article 69 1B, which obligates the state to work towards achieving and maintaining a tree cover of at least 10% of the land area in Kenya. The first respondent has denied the allegations of violations of the Article 69 of the Constitution. In summary, can you mute all? In summary, the response to this specific allegation is that the impugned road project is one of the Vision 2030 road project. The country Vision 2030 policy program seeks to transform the economy into a middle-income economy by 2030. They emphasize that the environmental conservation must go hand in hand with development, adding that environmental conservation does not imply objection to or freeze or of any form of development. The first respondent has denied the allegation of violation of Article 69 of the Constitution. In summary, the response to this specific allegation is that the impinged road project is one of the Vision 2030 road projects. The Country Vision 2030 project policy program seeks to transform the economy. I think it's a repetition. They emphasize that environmental conservation must go hand in hand with the development, adding that environmental conservation does not imply objection or freeze to any form of development. The first respondent has given a detailed breakdown of all the activities that culminated in the issuance of the impinged EAI license by the fourth respondent. They emphasize that the law was fully complied with in issuance of the EAI license. In further answer to the allegation of violation of Article 69 of the Constitution, the first respondent cites the mitigation measures contained in 1. the ICIA study report, the condition attached to the EAI license, and the measures outlined in the joint technical report. We have considered the allegations of violation of Article 69 of the Constitution. We have evaluated the evidence and the arguments tendered in support and against the allegations. Article 69 of the Constitution provides as follows. 1. The state shall ensure sustainable exploitation, utilization, management, and conservation of the environment and natural resources, and ensure the equitable sharing of accruing benefits, work to achieve and maintain the tree cover, at least 10% of the land area of Kenya, protect and enhance intellectual property in indigenous knowledge of biodiversity and genetic resources of the communities, encourage public participation in management, protection and conservation of the environment, protect genetic resources and biological diversity, establish system of environmental impact assessment, environmental audit and monitoring of the environment, eliminate processes and activities that are likely to endanger the environment, and utilize the environment and natural resources for the benefit of the people of Kenya. 2. Every person has a duty to cooperate with the state organs and other persons to protect and conserve the environment and ensure ecologically sustainable development and use of the natural resources. End of quote. So have the petitioners demonstrated the state's abdication of its obligation under Article 69(1) of the Constitution. So having evaluated the evidence on record and the arguments that were advanced in this petition by the petitioners and the fifth interested party on one part and the respondent and some of the interested parties on the other part, we are unable to come to a conclusion that the state has abdicated its constitutional obligation under Article 69 of the Constitution. And why do we come to this conclusion? In 2009, the fourth respondent, that is the state agents responsible for issuing AIE license, rejected the first respondent application for the EA license for the road project. The fourth respondent itemized the following as the reasons for the rejection. 1. The AE report fails to provide alternative routes for the proposed project in order to mitigate on the identified adverse impacts on the natural resources. The proposed road alignment will traverse 25 kilometers through close canopy forest. The proposed project will have massive impacts on the natural forest during construction, and it is possible that some endangered tree species may be affected. The Aberdare forest is one of the 5 water towers, and it provides water to Nairobi County and feeds Lake Naivasha, which is a backbone of Kenya's horticulture. Number 4, the proposed mitigation measures are inadequate in terms of addressing the anticipated negative impacts. And number 5, we have received strong objections from the Kenya Wildlife Service, Kenya Forest Services, African Wildlife Foundation, Lino Kenya Tourism Federation, and EAWS. So the above rejections happen notwithstanding notwithstanding the fact that the project was one of the State Vision 2030 projects. It took the first respondent about 14 years to undertake and complete the new EAC study based on more exhaustive terms of reference that were approved by the fourth respondent and addressed all the areas that had been identified by the fourth respondent in its rejection letter dated 27th of October 2009. The new ECR study report identified detailed anticipated impacts. For each identified impact, the report contained specific mitigation measures. Satisfied that the new ECR study had addressed all the concerns that had been raised in the year 2009, the fourth respondent issued conditional AIE license. The conditions are many and have been categorized. I don't have to repeat them here. We have already evaluated the mitigation measures in both the ECR study report and in the EIA license, and we have made a finding to the effect that the measures are adequate and will protect and safeguard the environment if fully implemented. Given the above evidence, we do not think that there is a proper basis for the petitioner's contention that the state has abdicated its responsibilities under Article 69(1) of the Constitution, thereby violating the said constitutional framework. And in making the above finding, we are guided by the principle of sustainable development that meets the needs of the present generation without compromising the ability of the future generations to meet their own needs. It is clear from the fourth respondent's letter dated 27th of October 2009, the Joint Technical Committee, the ECR study report, and the detailed conditions in the EAA license that the state took an integrated approach that addressed the concerns that have been raised by the stakeholders, including the first respondent herein. For the above reasons, we come to the finding that the petitioners did not prove the allegations of violation of Article 69(1) of the Constitution by the respondents. So when I come to the third issue, whether the first respondent was required by the law to procure a strategic environmental assessment study, the CEA report, for the proposed Mau Mau Road 4 Ihithe Ndonyonjeru Road project. The petitioners and the fifth interested party faulted the first, second, and the fourth respondent for failing to conduct a strategic environmental assessment CEA study on the proposed road project. They relied on Section 57A of IMCA and the Rule 42 of the Environmental Impact Assessment and Audit Regulations 2003. In response, the first respondent argued that strategic environmental assessment study was not a requirement for the issuance of the EA license and contended that a strategic environmental assessment study was only a requirement in relation to policies, programs, and plans. We have considered the above argument and counter-arguments, and we come to this conclusion that a strategic environmental assessment is defined in Section 2 of IMCA as follows. I quote, a formal and systematic process to analyze and address the environmental effect of policies, plans, programs, and other strategic initiatives. The requirement for a strategic environmental assessment was introduced into Kenya environmental law in 2015 through an amendment to IMCA. The amendment introduced Section 57A, which provides as follows. 57A, I quote, all policies, plans, and programs for implementation shall be subject to the strategic environmental assessment. 2. For the avoidance of doubt, the plans, programs, and policies are those that A. Subject to preparation or adoption by any authority at regional, national, county, or local level, or which are prepared by authority or for adoption through a legislative procedure by parliament, government, or if regional, by agreements between the governments or regional authorities, as the case may be. B. Determined by authority as likely to have significant effects on the environment. 3. All entities shall undertake or cause to be undertaken the preparation of strategic environmental assessments at their own expense and shall submit such assessments to the authority for approval. Number 4, the authority shall, in consultation with the lead agencies and relevant stakeholders, prescribe rules, guidelines in respect of strategic environmental assessments. End of quote. So, the relevant regulatory framework that exists in SEA study at the time the impinged EAE license was issued was Regulation number 42 of the Environmental Impact Assessment and Audit Regulation 2003. Regulation 42 provides as follows: lead agencies shall, in consultation with the authority, subject all proposal for public policy, plans and program for environmental implementation to a strategic environmental assessment to determine which ones are the most environmentally friendly and cost-effective when implemented individually or in combination with others. The assessment carried out under this regulation shall consider the effect of implementation of the alternative policies, actions, taking into consideration A, the use of natural resources, B, the protection and conservation of biodiversity, C, human settlement and cultural issues, C, socioeconomic factors, and C, protection, conservation of natural physical surroundings of scenic beauty, as well as protection and conservation of built environment of historic or cultural significance. We have carefully examined both the substantive framework in the Environmental Management and Coordination Act, that is IMCA, and the regulatory framework in the Environmental Impact Assessment and Audit Regulation 2003, which prevailed at the time the impinged EAE license was issued. Nothing in the substantive environmental law, that is IMCA, obligated the first respondent to conduct a CA study prior to applying an EIA license. Nothing in the substantive law obligated the fourth respondent to demand a CA study report from the first respondent prior to issuing the EAI license, and nothing in the regulatory framework required the first respondent to procure a CA study report. Similarly, nothing in the regulatory framework required the fourth respondent to demand a CA study report before issuing an EAI license to them. If Parliament wanted the CA report to be a mandatory requirement prior to the issuance of the EAI license for a road project such as the one that is the subject of this matter, that is the petition, it would have put in place a statutory framework to that effect, the way it enacted Section 58 of the IMCA in relation to EACA study report. So the current regulatory framework on strategic environmental assessment study is the Environmental Management and Coordination Strategic Integrated in Environmental Impact Assessment and Environmental Audit Regulation 2025. The framework was not in force when the impinged EAI license was processed and subsequently issued to the first respondent in the year 2024. It can therefore not be a proper basis for the contention that there should have been a strategic environmental assessment study prior to issuance of the EAI license in the year 2024. Although the above cited regulations of 2025 did not exist and were not applicable in 2025, we have taken the liberty to examine them to understand whether the CEA study report is at the moment a requirement for the issuance of the EAI license for a road project. Regulation 2025 contains the following provisions on the necessity for strategic environmental assessment. 5A, no ministry, county, department, agents, institution or private entity shall implement any policy, plan or program without undertaking a strategic environmental assessment. 2, every ministry, county, department, agents, institution or private entity shall submit a policy, plan or program brief to the authority for review. Number 3, the authority shall review the policy, plan or program brief to determine if a strategic environmental assessment for the policy, plan or program is required. 4, where the authority notifies the ministry, county, departments, agents, institution or private entity that a strategic environmental assessment is required for the policy, plan or program submitted for review under sub-regulation 2, the ministry, county, department, agents, institution or private entity shall apply to the authority for approval of the policy, plan or program. And 5, the application made under the sub-regulation 4 shall be accompanied by a fee described in the 4th schedule. It is clear from both the pre-2025 and the post-25 legal framework that a strategic and environmental assessment is a statutory assessment that is undertaken for the purpose of informing policies, plans and programs that the government, public institution or private entities intend to implement. Secondly, under the law that prevailed in 2024, a strategic environmental assessment study was not mandatory requirement for the granting of the EAI license for road projects such as the one in the present dispute. Even if it were the case that a strategic and environmental assessment study was required for the general implementation of policies, plans and programs, such as the Vision 2030, which informed the conceptualization of the contested project, the Cabinet Secretaries responsible for the relevant policies, programs and plans were not sued in this petition. They have not been heard in this petition, and under the Kenyan's legal system, they cannot be condemned and heard. So, having said all that, the totality of the foregoing is that under the law that existed in 2024, the first respondent was not obligated to procure a strategic environmental assessment study report for the purposes of the EAI license, and that is our finding on that issues. Therefore, it follows that we did not find any merit in this petition herein, and accordingly we hereby dismiss the same entirely, and we make no orders as to cause. That's the judgment of the court.